Like I said, good afternoon. Thank you for joining us today. My name is Lori Drake, and I am the Building Blocks Community Manager here at Handle. I have provided my information here. You can always look up Building Blocks and just join that, and you won't miss any of the information. If you haven't heard about Handle, we have a platform that is purposely built for building materials suppliers, focusing on lien rights management, job research, waiver compliance, which is one of my favorite, and as well as a dedicated payment portal. Today, I want to thank you for joining us for tips and tricks for working with disadvantaged business enterprises. Today, I would love to introduce you to our speaker. It's Deana Reynolds. She is the Director of Credit with Edges Electrical Group. Deana has been with Edges Electrical Group for over 9 years, where she had started as a credit manager, and from what I saw, just got promoted about a year ago to their director. Congratulations.
Thank you.
She received her bachelor's from the California State University and has been speaking at the Credit Management Association and National Association of Credit Management conferences for quite a while. In addition, she was just recently elected as board chair for the National Credit Management Association and as a speaker for the Women Leaders in Credit and Finance, which is a dedicated mentorship initiative program, which down the road, I would love to hear more about that. I'm so excited to welcome Deana today, and I'll let you take it from here.
Thank you so much, Lori, and welcome everybody. We're going to have some discussions today about disadvantaged business enterprise. It's a big issue that's been coming up in construction over the last few years, and it's one of the least understood programs that we have. So I wanted to go over this with you. I do have to preface this by saying I am not an attorney, so that if you do have some questions about this, because there are legalities involved and you have an attorney on your staff, it wouldn't hurt if you needed to get advice from them. But let's go and give you kind of an overview on what this program is. So what we're going to talk about today is what is a DBE or a DVBE, which is another phrase that a lot of people have been using. What is that program? We're going to talk about how this affects your company, some court cases over the past few years, what now, what is the correct procedure, and some red flags to watch out for, and what our responsibility is when we're dealing with these programs. So first of all, what is a DBE or a DVBE? DBE stands for Disadvantaged Business Enterprise. Now that could be made up of a DVBE, which is a Disabled Veterans Business Enterprise, a woman-owned enterprise, a minority-owned enterprise, and there are actually other categories, but these are the primary ones that you may see in your work. And so what is the DBE program? So this was established by the Department of Transportation in 1980, and it's been reauthorized several times, most recently in 2021, so this is still ongoing. And the primary goal of this program is to level the playing field by providing disadvantaged business enterprises a fair opportunity to compete for federally funded transportation contracts. That's why it was begun by the Department of Transportation first. Now it's being used by plenty of other agencies. And in fact, California specifically, their goal is 3% of all state contract dollars should be going to disadvantaged business enterprises. So how does this affect your company? Now, you may be a supplier or you may be a contractor, but this is primarily in construction, and it's for government-funded contracts. Now, how this may affect your company is if you are not a DBE supplier, you need to know what the rules are and how to comply. You may get customers that ask you for a bid, and then after you bid the job, they then tell you that you have to bill a DBE for it. Too many people just don't understand the rules, which is why I've been making it a point to spread the word as much as possible. And we are all at risk, and I'm going to explain to you exactly why that is. Here's some recent court cases, and these affect businesses that did not comply with these rules. And I'll explain these as we go. So the biggest one, some people may have heard about this one already, HD Supply and American Indian Builders. And what happened here, American Indian Builders was hired as a subcontractor for DBE requirements because they were a minority-owned business. What happened is they didn't actually do the work. They acted as a pass-through. So a non-DBE contractor actually did the work, but American Indian Builders provided the billing for it to give the appearance of these of this work being done by a minority-owned business, but it was not. So the resulting fine in this particular case for HD Supply was just under $5 million. So as you can see, this is actually a big deal. People for years now have been having suppliers and contractors basically acting as a pass-through, not actually doing the work, but just passing the paperwork to satisfy this requirement. And these are the kind of things that you can expect.
Deana, we have a question. Sorry.
Yes. No,
we might
of course.
be coming to it later. How did they figure it out in order to find them?
On this particular one, I don't know how it was investigated, but I know that in other court cases, what I've seen happen, and I don't have the citation for it right in front of me, but one of the things that happened was a legitimate DBE contractor or supplier discovered that they were losing out on these jobs due to a pass-through, and they have brought it to the attention of someone.
That makes sense.
Yeah, other cases, it's literally been a disgruntled employee who thought this was a load of garbage. They didn't like it. They didn't think it was ethical and acted as whistleblowers. So we're going to go through a couple of more court cases, but I can tell you I don't have the how the investigation happened, but I've seen it in various different ways. You just need one person to speak up to the right people, and that gets the authorities involved.
Yeah.
All right. Next court case we have is United States versus Azteca Supply Company. So in this one, Aurora Venegas, this lady was the owner of Azteca, and she supplied material for projects at O'Hare Airport. And she's a DBE supplier because this is a woman-owned business. It was discovered that she was acting as a pass-through for a non-DBE supplier. So once again, a standard supplier that is not a small business or minority-owned or woman-owned or any of that was actually supplying the material. She's passing the paperwork. So that's why it's called a pass-through. And the result, she had to forfeit all of her profits, $482,000. And she went to prison for over 2 years. So as you can see, it's not just money. People are going to jail because this is technically, it's fraud. Here's another one we've got, United States versus Stamatios Cassis. Mr. Cassis was the owner of Alpha Painting and Construction, and he used a pass-through supplier to satisfy DBE requirements on several bridge projects in Pennsylvania. So meaning that the person he was, quote, purchasing his material from was not a legitimate supplier. They were acting as a pass-through, and he was aware of it. And so as a result, fines and fees of $18,000 plus and 70 months in prison. One of the reasons this was a higher number of months in jail is because this was over several projects and they were pretty large. United States versus Joseph Nagel. And Nagel is the owner of Skykill products, and he used a small DBE firm known as Marikina as a front for DBE contracts for over 15 years. So this is a long-term, they actually used the word scheme when I was researching this. As a result, fines and fees of $27,600. Now, keep in mind, this is over 15 years that he was knowingly doing this, 84 months in prison. And if you want to do the math, that's 7 years. So that's a significant portion of his life for the money that he made, basically scheming for these projects that he really wasn't entitled to.
We have another question.
Okay.
Why is it that the fines for the person actually doing this are so much less than the supplier was fined on that first case?
You know what? That's a great question. I can't tell you. I think it's up to the individual judges or juries in these court cases to determine what the sentencing and what the remuneration is going to be for those. And it's a little bit inconsistent. You know, some of these were fined, $5 million. This fine is only $27,000 when you know for a fact that he made a lot more than $27,000 over 15 years. But that's also why the prison sentence is so high. I am not the judge, so I can't tell you exactly why they decided it this way. But my main point for all of us who may be dealing with construction projects that have a DBE component is that we're at risk and everybody involved is at risk. My company is a supplier and we frequently get these requests. Customer asks us for a bid. We bid them for a whole job and then they go, oh yeah, by the way, this has to go through a DBE after we've already bid them. And what we have to do at that moment is we have to tell them, I'm sorry, we are not a DBE, therefore this quote is null and void. You'll have to go find a DBE for yourself. They don't like that answer, but that's what we have to do if we want to stay on the right side of the law, because I'll tell you what, I'm not going to be complicit and I'm not going to jail.
Absolutely. I agree.
Yep. All right. So now that we know what some of these huge, huge consequences are, what now? So first of all, a legitimate DBE must have a commercially useful function. And this is actually a legal phrase that's in the law. They can't just be a pass-through. They have to actually do something. Okay. Number one, they have to be the ones to negotiate price. They must determine the quality and quantity of material. In this case, we're talking about a DBE supplier specifically, but this can also, work if it's a DBE contractor. The DBE must be the one to order the materials. They must pay for the materials directly. Oh, let me back up. That went too quick. They must pay for the materials directly. Now, again, using that same example of what happened to us, where we had to shut down the entire conversation with the customer and say that we are not a DBE, therefore this quote is no longer any good. So what they had to do is they had to go out and find their own DBE supplier to satisfy this requirement. They had to request a quote from that DBE supplier. Now that DBE supplier sourced some of the materials from us, but our discussions were only with that DBE company, not the end user who also happened to be our customer. We can no longer talk to them about it. We can't arrange for delivery. We can't talk specs. We're not selling to them for this project. We're selling to the DBE. So that's the only people that we can actually talk to for any of this. So what is the correct procedure? I kind of went over it a little bit, but this is an example of how this should work. The general contractor tells your customer, we're just going to call them sub because we're going to guess they're a subcontractor. GC tells your customer, named sub, that 10% of his materials must come from a DBE supplier. So the sub contacts a DBE supplier, we're going to call them, just for the purposes of this, DVBE Supply as their company name. So sub contacts DVBE Supply and asks them for a bid. If DBE Supply does not have the material in stock, they will request bids from whichever distributor they wish. Now, the GC cannot tell DVBE where to source their material either. They can't be part of that conversation. DVBE turns around and gives sub their bid. Sub accepts the bid and gives DVBE a purchase order. The sub and DVBE remain in communication until the project is complete. So, what did you not see in that list of steps? Your company was not in that list of steps. And Lori, is there another question?
There is. We want to go back one more slide. It related to.
Okay.
So you said that they have to use 10% of the materials from a DBE. The GC can't say, hey, here are some DBEs or VEs.
The GC can say, here are some I know of, but they can't come to us as a non-DBE supplier and tell us when we give a bid, they can't go, oh, 10% of that material, you got to bill it through a DBE.
Right.
That doesn't work because now we have the GC or the sub getting in between my relationship with my other customer who happens to be the DBE supplier. They can't tell us, here's an example of something terrible that happened. Someone who no longer works here had this happen, had a customer of theirs, this is a salesperson, a customer of theirs said, got a bid from us, and let's just say it's $100,000 for ease of math. And they said, oh, by the way, 25% of that has to go through a DBE. And she says, no problem, we'll find you one and they'll mark it up 2%. Okay, that is the very definition of a pass-through. And she put her entire company at risk by doing that.
And this kind of piggybacks off of that question. Is there somewhere to find a list of what suppliers are DBEs?
So typically, honestly, if you Google DBE supplier in your town, they will probably show up. Many of these DBE suppliers actually put DBE in their name. It might have it on their website. But yeah, you can ask us, like if I have a customer that says, I can't buy from you on this because I have to go through a DBE, I can share names and contacts of ones that I know, but I can't recommend any. I can't say I'm a partner with any. I can just say, here's some publicly available information of some that I know that are in this town. Now, that DBE supplier is still not required to purchase from me, even though I may have shared their name and number, because I cannot have any collusion or anything like that in this relationship.
Thank you.
All right, so continuing on. So once again, your company was not in that list of steps because you cannot get between the DBE and their customer. So some red flags to look out for. Number one, if the contractor tries to order material directly from your company and you are not a DBE supplier, huge red flag. Contractor wants to use joint checks. In construction, we are kind of hardwired to think that joint checks are the best way to go. But in this case, it's not. Been advised by an attorney that a joint check between the contractor and the DBE who's purchasing from me is just one more red flag that it's a pass-through, because we should not be part of that conversation at all. The contractor wants to negotiate price. Once again, it's very similar as if you have two customers, maybe, or even competing. You don't share price information about one customer with another customer, regardless of who it is. your responsibility in this whole process is, number one, you need to protect yourselves by making sure that you're very clear on what these rules are, is how you're going to keep yourself out of trouble. You want to follow the law 100%. And if you do have questions, I highly recommend you getting advice from an attorney, specifically a construction attorney. I know some. If anybody wants to reach out, Lori does too. It's probably some of the same ones who are really, really great at sharing this information and talking not like a lawyer, but like an actual person who you can understand. Chris Ing's one of them. He's the best. He's where I learned most of this, by the way. You do not want to be complicit. And a final warning is, if you're a supplier, in case you're not aware, or if you've forgotten, there are no lien rights on supplier to supplier sales. So that means if you're selling to a DBE, they have to be creditworthy, as all sales are unsecured. And if you file preliminary notices on those jobs, it's basically useless because you don't have rights to file a lien, a stop notice, a bond claim, or anything. Is there a question?
Yes. Question is, you said something about supplier to supplier, that there's no lien rights. What do you mean by that?
So typically as a supplier, I can do a preliminary notice on my job, and that gives me the right to file a mechanics lien. Or if it's public works, I can do a bond claim or a stop payment notice if we don't get paid. But if you're selling to another supplier, you don't have the rights to any of that. It's completely unsecured, and it's based only on their credit. I've had a couple of customers that have given me credit applications recently that wanted to do a $100,000 purchase from us, but they're another supplier and their credit's good, but it's not $100,000 good. So we ended up having to get like a big deposit in order to continue to do that, because we won't have any rights to file a mechanics lien on the job if we don't get paid.
Interesting. There is an add-on to that. They are a supplier who sells to another supplier, but that supplier owns the property in which they're running their business out of. So like a landlord way, is there a way to get rights on those?
If so, to piggyback on that, yeah, if I'm selling to a supplier, but the material is going for improvements on their own building, then I'm technically selling to the property owner as an owner builder. I'm not selling them as a supplier that's going to turn around and resell that material to somebody else. So my instincts tell me I would have lien rights on that if the material is going into their building, because you do automatically have lien rights when you're selling to the property owner directly. But it's a gray area, and I would say you might want to either check with your attorney in your state to be 100% sure that's correct, or just make sure that you're selling to somebody who's creditworthy for the amount that you're selling, just to make sure that you're protecting yourself and your company's money.
Thank you. And it sounds like we have a topic for another webinar.
Yeah, maybe so. Maybe so. That's for sure. There's a lot of really weird loopholes on lien rights, and then it depends on what state you're in too, because not every state is the same. Right. My primary expertise is in California, although we do sell in other states, but the majority is in California. So that's where most of my knowledge is. Right. And if your state may have it slightly different, but the DBE component is a federal program by U.S. Department of Transportation, but just a lot of states and local governments are using the same requirements. And so the law is the same for those.
Thank you.
Okay. Let's see. Continuing on, knowing that the DBE has to be creditworthy, you want to know your customers. You don't want to just have somebody come in off the street and go, yeah, I'm a DBE and I got a great job I'm bidding and it's $100,000. Sell to me, no problem. It's no problem. So anybody who's in credit knows what to do in this situation to make sure they're credit worthy. And now we're just to the Q&A portion. So that's all I have for lecture content. So what other kind of questions might we have from anybody?
If you have a question, please raise your hand. I can take you off mute, or you can put it in the chat. Well, I'll give you a question. You know how people can bond around the lien. Can a supplier bond around risk that you're selling to a DBE?
No, as far as I know, there's really no loophole. The only thing is if you might have trade credit insurance, as you would for any other unsecured sales that you're making. You can if you have trade credit insurance on your AR, this would be included in that, but there's no rights on the job itself, because technically you're selling to a supplier and the GC doesn't know you exist, the property owner doesn't know you exist, and the subcontractor is not supposed to know you exist. So hopefully they don't either. So you're just like off here by yourself.
Tracy put in the chat that this is great information. I mean, you've given me probably like another 2 or 3 webinar ideas. So we might keep Deana busy this year.
I'll be here. I'm always happy to share 100%, because I don't want anybody to get in trouble with this stuff. And honestly, the first few years here, I was doing this completely wrong. And it wasn't until, honestly, I went to a webinar like this and had the shock of my life to find out how much we were all at risk. And so I've made it a real mission to inform people on this, because it's really scary. No, I don't want to go to jail because of an accident. My job.
I want to thank you again for taking your time to speak with us today. It was great information.
Of course.
And for all those that joined, we'll see you next time.
Okay.
Have a great day.
Thank you, everybody.